Hived and the Secretary of State for the Company House.
Yes, Mr. Malik, our apologies for keeping you waiting.
Lords, I appear for the appellant this morning with Mr. Badda. Ms. Henderson appears for the Secretary of State. My Lords, there are two issues in this appeal. First, what test Judge White should have applied in deciding whether to reopen the finding made by Judge Randall that the appellant had not relied on false bank documents. And second, whether on the correct test, Judge White was entitled to reopen that earlier finding. I shall seek to persuade my lords that Judge White should have applied Laird and Marshall test, attaching due weight to the principle of finality of litigation and the statutory scheme of immigration appeals. I shall also submit that it was not open to Judge White to reopen the finding made by Judge Randall. Subject to any observations, what I propose to do is to make 5 short points on the law first, and will then make some very brief submissions on the facts and on the decisions made below. So first, the law, my lord, 5 very short points. The first point, naturally, is that Judge White should have applied Laird and Marshall test. The authority for that proposition is this court's judgment in Ulla. My lords, you have that authority behind tab 5 of the authorities bundle. May I respectfully take my lords to that authority just to make the proposition good and show my lords as to what this court said in that case.
By all means.
Behind tab 5, page 108 of the authorities bundle. Lords will see the basic background facts at paragraph 3 with issue summarized at paragraph 2. And if you look at paragraph 2, you'll see the question that was before the court, namely, what the Secretary of State ought to do if she finds fresh evidence suggesting that the original claim to indefinite leave to remain, which was upheld on appeal by the tribunal, was fraudulent. In that case, the appellant succeeded before the tribunal in his appeal on the ground that he had resided in the United Kingdom continuously and lawfully for 14 years. This is paragraph 3. Paragraph 7, thereafter, the respondent, the Secretary of State, obtained evidence that the appellant, in fact, was in Pakistan making various applications on a different passport. The Secretary of State, despite the finding made by the First Tier Tribunal, cancelled the appellant's indefinite leave to remain, which gave rise to these proceedings. So may I take my lords to paragraph 25 of the judgment of Lord Justice McComb. You'll see at that paragraph a citation from an earlier case, the case of Belfield. And if you look at the first quotation, you'll see that Ms. Justice Moses, as then was, made it plain that the Secretary of State is not entitled to disregard a decision made by the tribunal unless he can set aside that decision by appropriate procedure founded on appropriate evidence. That is then clarified in the next quotation, and you'll see that the Secretary of State can ask the tribunal to revisit its decision on the basis of fresh evidence as long as that evidence meets the Ladd-Marshall test. If you then look at the quotation at paragraph 26, you'll see that a particular emphasis was placed on the principle of finality in litigation. Now, the effect of this authority is summarized by Lord Justice McComb at paragraph 31. And you'll see that he again makes it plain that it's Ladd-Marshall test that applies. And the reference to this case is to the case referred earlier.
Could we just pause when looking at this in the context of Buller itself?
Yes.
That was a case in which, as was said in paragraph 31, the previous decision was that someone was entitled to leave to remain. That wasn't quite the situation in this case.
Lord, I accept that entirely. There wasn't any declaration by the tribunal that the appellant was entitled to indefinite leave to remain. But in my respectful submission, the principle applies here with equal cogency. When I'll make my second and third propositions, I'll explain how the law developed.
Sorry, I interrupted you in your survey of Buller.
Yes, Lord, perhaps just to assist you in relation to the question that I just asked, that you just asked, my Lord. If you look at the background facts, this paragraphs 3 and 4, you'll see that the appellant had succeeded on the ground that he had resided in the United Kingdom continuously, lawfully for 14 years. There isn't an absolute entitlement to indefinite leave to remain, even if a person resides in the United Kingdom continuously, lawfully for 14 years. There is a discretion. So one has to, in my respectful submission, look at, consider the language that is used at paragraph 31 in that context. Then, my Lord, if you look at paragraph 36, there is a quotation from the judgment of Lord Justice Stanley Burnton in the case of TB. And
TB, yes.
Yes. And you'll see that the point was made that the Secretary of State cannot be right for the Secretary of State to circumvent the decision made by the tribunal by an administrative decision, because that would undermine the statutory scheme. The overall conclusion is at paragraph 43, where Lord Justice McComb endorsed what Mr. Justice Moses, as he then was, said in the case of Sarabeel that I've just shown you.
The conclusion in the case itself is at 42, isn't it?
Yes. And 43 is...
Yeah, analysis.
Yes.
See that.
Ladd-Marshall. Now, you'll see this is the last sentence of paragraph 44. In that case, there was no issue that Ladd-Marshall test was not met, and the court simply clarified that it's Ladd-Marshall test that applied. The court took the view that the upper tribunal had applied Ladd-Marshall test and dismissed the appeal for that reason. Lord, my second proposition is that in cases of this nature, if the Secretary of State fails to produce all the relevant evidence at the tribunal that ought to have been or could have been produced with reasonable diligence, she cannot then seek to reopen the tribunal's decision in subsequent proceedings. The authorities for this proposition are the upper tribunal's decision in Mubu and this court's judgment in BK, Afghanistan. So instead of showing my lord's Mubu, may I show my lord's BK, Afghanistan, because Mubu was considered in that case. And that was a case where this court reconciled the principles set out by the Asylum and Immigration Tribunal, as it then was in the case of Devasilan, and what the upper tribunal had said in the case of Mubu. So you have BK, Afghanistan behind tab 4 of the authorities bundle. Starts at page 96. So that was a case where in 2002, the appellant had claimed asylum. That claim failed, and on appeal, the tribunal found that the appellant, working as a bodyguard with one of the Taliban commanders, had tortured people when instructed to do so. The appeal failed. The appellant left the country in 2007. He re-entered the country as a spouse, and then ultimately he was given indefinite leave to remain on that basis. When he applied for indefinite leave to remain, he said nothing about what he had allegedly said in 2002 and about his activities in Afghanistan working for the Taliban. The Secretary of State cancelled indefinite leave to remain on the basis that the appellant was dishonest and that what had said in 2002 was not brought to the Secretary of State's attention. There was a right of appeal, and this time the tribunal departed from the findings made in 2002. And it was the Secretary of State, conversely, in that appeal, who was seeking to argue that the second judge should not have departed from the findings made by the first judge. Lady Justice Rose, as she then was, gave the judgment. And if you look at paragraph 32 of her judgment, this is page 102 of the bundle, you'll see that she outlined 8 principles in the case of Devasilan. Lords may have come across this case. This is a classic.
Sorry, just for a moment. Could you just run through in a sentence what each of the previous tribunals had decided, the FTT and the UT in that case? What was the conclusion in the FTT? What was the conclusion in the UT?
So the First Tier Tribunal's decision was set aside by the upper tribunal. The upper tribunal effectively remade the decision. And in remaking the decision, the upper tribunal, sitting essentially as the fact-finding tribunal, departed from the findings made by the judge in 2002 and accepted the appellant's evidence that he had not worked for the Taliban, and he did not say what was attributed to him in the first judge's decision. And that was the context in which there was a discussion about the principle of finality in litigation and the relevant.
So the UT outcome was favourable to the applicant.
Yes.
And you succeeded on appeal on behalf of the Secretary of State.
No, I lost.
Sorry, it's the other way around.
Applicant succeeded in the UT, and you failed to persuade this court to overturn the UT.
Absolutely. Yes.
Yes, I'm sorry. Thank you.
Yes.
I'm getting there. Yes.
Yes. Now, if you look at paragraph 32, so this is where Lady Justice Rose summarized 8 principles in the case of Devasilan. Now, Devasilan, my lords, may have come across this classic case from 2002. I mean, it happens in this jurisdiction with some frequency that an asylum seeker would claim asylum, the appeal fails, he then comes up with new evidence, makes a fresh claim, there is then another appeal, and Devasilan provides guidance as to how the tribunals should approach the second appeals. But for the present purpose, it's principle 6 and 7 that are relevant. I mean, of course, they do not apply to the Secretary of State as such, they apply to the appellants. But I shall explain how the court applied those principles equally in the same manner where the Secretary of State seeks to rely on fresh evidence. And if you look at paragraph, the principle 7 in particular, you'll see that a point was made that unless there is a very good reason why the appellant failed to adduce relevant evidence before the first adjudicator, and if you read 6 and 7 together, essentially the point is that, well, if the appellant had some piece of evidence that he did not bring to the judge's attention, there wasn't any good reason as to why he failed to do so, the second judge should treat the issue as settled. But if there is a very good reason why it wasn't brought to the judge's attention, the appellant was not properly represented, for example, then that may be a good reason to depart from the first decision. Now, how that applies to the Secretary of State was discussed at paragraph 37. So paragraph 37, in my respectful submission, is an accurate summary of the upper tribunal's decision in Mubu, which you have behind tab 10 of the bundle. But for the present purpose, what is said at 37 is enough. May I respectfully invite my lords to read paragraph 37 in full, because that is crucial to my argument. So one can see with respect the immediate similarity of that case with the present case. There was an allegation of deception. There was an appeal. The appeal resolved the tribunal resolved the issue in the appellant's favor. The dispute essentially was about a birth certificate. After the decision of the tribunal, the Secretary of State obtained fresh evidence to the effect that the birth certificate that was the subject of earlier appeal stated that the appellant was born in a particular hospital that was billed many years after the date on the birth certificate. So the implication was that the birth certificate was false. When the matter reached the upper tribunal again, the upper tribunal ruled again in the appellant's favor for the reasons set out in the quotation that you have at paragraph 37, attaching weight to the principle of finality of litigation. And you'll see that the tribunal made it clear that the Secretary of State failed to produce all the relevant evidence to the judge that ought to have been or could have been with reasonable diligence made available to him. And in those circumstances, the first decision should be treated as settling the issue about the relationship between the first claimant and the person in question.
Yes. So the outcome was the same, namely that the applicant succeeded in Ruby, but the issue was whether the first decision was to be treated as conclusive or whether it was to be treated as a starting point.
Yes.
And here the upper tribunal says it's to be treated as a starting point, as per Della Salem, and went on to treat it as a starting point and found that the conclusion favoured the applicant.
Lord, that with respect is not the submission that I make. So what the upper tribunal said in that case was that the first decision should be treated as settling the issue. So the tribunal declined to reopen the matter and to address and to take account of further evidence that the Secretary of State had produced. The tribunal said that, well, the Secretary of State should have provided this evidence earlier in the earlier proceedings, and given that there is no explanation, no proper explanation as to why that evidence wasn't provided, we are not going to look at it again. We are going to treat the first decision as the conclusive decision deciding the issue for good. So that is.
Is that your characterization of the upper tribunal decision in Nugee?
Yes, and that, in my respectful submission, is how this court read that decision in BK. If you look at the quotation in paragraph 37, and second sentence in the quotation, we bear in mind, however, that the nature of the issue now in dispute between the parties was the same issue that was determinative of the appeal before Judge Tipping, namely the first judge. And then the failure by the Secretary of State to reduce evidence before the first judge, and the upper tribunal said quite clearly in my submission that the first judge's decision should be treated as settling the issue of relationship. So no question about entitlement to indefinite leave to remain. The tribunal is simply concerned with a discrete issue that was in dispute. Wasn't a proper explanation put forward by the Secretary of State as to why the evidence wasn't reduced earlier. Applying Ladd and Marshall test, the tribunal said that the matter should not be reopened. And that has, in my respectful submission, endorsement of this court in BK, Afghanistan.
If you look at paragraph 38, you may be coming to it.
Yes.
There, Lady Justice Rose refers to a campaign which it appears was a case where the evidence would not have met the Ladd and Marshall test, but was still allowed in and was determinative.
Yes.
How does that?
Yes.
How is that reconcilable
Yes.
with your submission
Yes.
that the Ladd and Marshall test always applies?
Yes. Yes. Because in that case, the parties to the original appeal were different from the parties in the subsequent appeal. I can take you, if you look at paragraph 38, you'll see that there was, the daughter had been granted on the same basis of her father's flight from Colombia. And the further evidence which the tribunal hearing the father's appeal had considered would not have met Ladd and Marshall test. So the daughter's appeal was decided by the tribunal. And there was no issue. The Secretary of State was not going behind what had been said in the daughter's appeal. There was then an appeal by the father, and that was the context in which the observations made at 38 were made. That the Court of Appeal this court could not have said that Ladd and Marshall test would not apply in cases of this nature, because that would have been irreconcilable with the case of Ullah and with the case of Mubu that the court has referred at paragraph 37.
But what Lady Justice Rose introduces this discussion at 37 was saying that the guidance, that's the I can't pronounce it.
Yes.
Devasilan?
Devasilan, yes.
Devasilan guidance shouldn't place unacceptable restrictions on the second adjudicator's ability to determine the appeal. And so the discussion seems to be premised on the base that there is an ability of a tribunal to depart from a previous conclusion. It seems antithetical to erecting strict rules in this area.
Well, Ladd and Marshall test applies, but it's always subject, I entirely accept, subject to a discretion by the court. This is what was said in the case of Mubu. A court can always depart from the first finding if it is in the interest of justice to do so. But in my respective submission, Ladd and Marshall is the touchstone in cases of this nature. That the point wouldn't apply if the parties to the subsequent appeals are not the same as the parties to the first appeal.
Before you go on, could I just have another go?
Yes.
So I'm trying to understand your submission based upon paragraph 37 and Mubu. I was reading the passage in the middle of the long first paragraph, in which it said that the UT held that there was an error of law. Res judicata not applicable. Devaseel and guidance applies equally to the parties.
Yes.
This is the bit that I had attempted to summarize,
Yes.
Which was that the FTT, which had simply said, well, the first decision is the end of the matter, was wrong. That it wasn't the end of the matter, but it was the starting point. And they went on to remake the decision, and as it happens, they reached the same conclusion on the further information. Now, I just want to be sure that I've understood whether I've not misunderstood this. It's
yes.
There's no
Yes.
estoppel arising from the previous decision, even if it's the same parties and the same issue. However, you don't likely depart from a previous decision about the same issue. You treat it at least as a starting point, and depending upon how much congruence is, no doubt it might be a swift journey to conclusion, that you don't interfere with it. But that must all depend upon whether you've got the same issue, whether you, what the evidence is, and the circumstances are.
My Lord, the reason why the tribunal the tribunal or the court expressed itself in that way was because it was argued in Mubu that res judicata actually applies to this case with
well, that's not an issue for us.
That's not an issue. Yes, and
yeah.
The upper tribunal set aside the first year's tribunal's decision on the basis that that is wrong. Res judicata does not apply. The upper tribunal then remakes the decision.
Yes.
And in remaking the decision, it declines to reopen the issue because the evidence the Secretary of State was seeking to rely on ought to have been or could have been adduced in the earlier proceedings.
That's right, but it's carrying out its own assessment and finding that leads to the conclusion that it leaves the first decision alone.
Lord, I accept that. It's entirely my fault. I may have misunderstood.
I just wanted to make sure, because it may be an important point, that I hadn't misunderstood your submission.
No, Lord, I do not dispute that. But the test that the upper tribunal applied, and the test that I would respectfully invite the court to apply in this case, is one that appears in the last sentence of the quotation at paragraph 37. If there is a failure by the Secretary of State to produce the relevant evidence that ought to have been, it could have been, with reasonable diligence made available at the first hearing, then the issue should be treated as settled. Not as a matter of res judicata or estoppel, but for the reasons given by the tribunal in that case.
Mr. Knight, the last sentence begins, in the light of these considerations, which is a reference to all of the matters set out in paragraph 66 of Mubu. So it's the overall circumstances of the case, doing justice to both sides, exercising the flexibility which was referred to in Lord Justice Judge's judgment.
Lord, in Mubu, there is an extensive discussion by the tribunal of all earlier authority, as the tribunal explains why res judicata does not apply, but why the principle behind the res judicata applies, and the principle of finality in litigation, of course. And then the tribunal said, well, in all the circumstances, that is the conclusion. But when I'll address the courts on the facts, I shall make an effort to persuade my lords that what has happened in this case is not materially different. So, my lord, that was the third. That was the second proposition. The third proposition, my lord, that I put forward is that is the point that I've just made, which is that although res judicata does not apply to immigration appeals, the general principle behind the concept of res judicata applies. A decision made by the tribunal will be treated as final and binding unless there is a legal, not a factual justification for departing from it.
Sorry, final and binding unless,
unless there is a legal and not a factual justification for departing from it.
that's the proposition.
That's the proposition. The authority for that proposition is this court's judgment in Adebayo. And that authority is behind tab 6 of the authorities bundle.
Thank you.
So my lords will see, this is paragraph 2 of the judgment of Lady Justice Andrews. The tribunal allowed the deportation appeal.
Just a moment.
Yes.
Just allow us to orient ourselves in this case.
Yeah.
Sorry, could you give me a page number?
Yes, so the authority starts from page 124 of the bundle.
Right, so it's deportation of foreign criminal.
Yes. So you'll see from paragraph 2 that the Secretary of State made a deportation order. The appellant was successful on appeal, but the Secretary of State made another deportation order because the law had changed, and the issue in the appeal was whether it was open to the Secretary of State to make the fresh deportation decision. May I respectfully take my lords to paragraph 43 of the judgment, so page 134 of the bundle. You'll see by reference to an earlier authority, Lady Justice Andrews endorsed what was said by Ms. Justice Chowdhury in that case, that the general statement of principle of finality in litigation applies in this context too. And if you read that particular paragraph with paragraph 45, you'll see that the effect becomes much clearer. The last sentence at paragraph 45, the doctrine of res judicata will not apply with its full rigor. The earlier decision will be treated as final and binding on the parties unless there is some legal justification for departing from it.
But you want to place weight on the word legal.
Yes, and
Well, shall we read 44 and 45 to ourselves?
I'll be grateful, Lord, yes.
Thank you.
If it assists, yes, 45, 46, 44 and 45, and
Sorry,
46.
I meant 44 and 45, thank you.
Yes, thank you.
Right, that's an observation.
Yes, so last sentence of paragraph 45 is what I invite the court to adopt and apply in this case. There is a further point that arises from this case, and that is summarized at paragraph 46. My lords will see that 46 starts with moreover, so this is an additional point. It is not open to the Secretary of State to raise fresh points that could and should have been raised before the original tribunal or on appeal in the proceedings that gave rise to the first decision. There must be fresh evidence which meets the Laird and Marshall test, see ULA, or a material change in the circumstances. If those conditions are not met, any attempt by either party to relitigate the same issue may be treated as an abuse of process, and any fresh evidence taken by the Secretary of State which is inconsistent with the earlier decision will be susceptible to judicial review. So again, in my respective submission, a clear endorsement that Laird and Marshall applies, and the Secretary of State cannot raise new points that she could have raised in the original proceedings.
I'm just interested in the aspect of this proposition, which I think you're advancing to show that there must be a legal and not a factual justification for departing.
Yes.
Does that rest upon any other foundation in this decision than the use of the word legal in the last sentence of 45?
Well, 45 and 46. I mean, if Laird and Marshall test is met, that in my submission would be a legal justification for departing from the original decision. If there is a change in the law, for example, then that may well be a legal justification for departing from the earlier decision.
So is your submission really, although there's no res judicata, the earlier decision will be treated as final and binding unless Laird and Marshall applies? Is that what it amounts to?
In this case, yes, but I cannot rule out that there may well be other cases where Laird and Marshall is not met, but the tribunal would be entitled to depart. For example, as was the case of Adebayo, where there was no issue about Laird and Marshall, but because the law changed after the tribunal's decision, the Secretary of State introduced a more rigorous deportation regime, and the new deportation decision was justified. But in a case of this sort, Laird and Marshall is the touchstone. That is the submission that I make. That is the effect of this judgment, paragraphs 45 and 46.
Can I understand this? You say that if this was ordinary civil law, private law litigation, the ingredients of issue estoppel or cause of action estoppel would be met.
Yes.
And although those principles, everybody accepts those principles don't apply in public law cases in the field of immigration, or indeed I think in public law generally, the same principles should apply, generally speaking, although not quite with the same rigor. Is that?
I'm very grateful. That is the point. Yes.
Yes.
That is the submission. Yes.
Well, can I raise something which concerns me, which is that in private law, the Supreme Court last year in Takar and Gracefield Developments said that you don't need to meet the Laird and Marshall test if what you're doing is seeking to set aside a previous judgment on the basis that it had been obtained by fraud.
Absolutely. Yes.
Does that principle equally apply in public law?
Well, if the tribunal makes a finding of fact on the basis of a fraud committed by an appellant, what the Secretary of State can do is to apply to the tribunal to set aside its decision on the basis that there was an administrative irregularity in the decision-making process, and the tribunal will then may reopen the matter, will consider the arguments, make a decision. But what she cannot do is not to challenge the tribunal's decision, not to apply to the tribunal to reopen the appeal on the basis that there is an administrative error, or not appeal that decision. But then simply remake the decision that was subject to the original appeal, as if the original decision had not been made. So I accept, my lord, that even in this context, it is an option for the Secretary of State, if she is satisfied that the evidence given by an appellant at a tribunal hearing was fraudulent, to seek to reopen that that case. But that did not happen in this case. Judge Randall made a decision. There's no application by the Secretary of State to set aside or reopen that decision. There was no appeal from Judge Randall's decision. The Secretary of State then simply remade the decision, in my submission, sidestepping the decision of Judge Randall.
So, have I understood this correctly? Do you accept that the Secretary of State could have applied to the tribunal to set aside Judge Randall's decision on the grounds it was procured by deception, and in those proceedings would not need to satisfy the Leiden-Marshall test?
Lord, I'm reluctant to give an answer because they
of course.
Yes, because there are detailed provisions in the procedure rules as to the circumstances in which a party may apply to set aside a decision, and those conditions are slightly different from the conditions that apply in CBR and in civil proceedings. So the honest answer is that I do not know, Lord, but that of course is not this case, because there was never an application by the Secretary of State to set aside the original.
Can we examine your logical progression to say that it was open to the Secretary of State, having come upon more information, to go back to the appeal tribunal, the FTT, and just consider the real world situation there. You say that considerations of finality in litigation drive that conclusion, but it's a very poor system if that's the case, isn't it? Because why does the FTT want to be troubled with revising its first decision when you have a perfectly good mechanism for the Secretary of State to remake the decision, and off you go to the FTT again if the applicant isn't satisfied, and then the FTT considers the matter on the basis of the real world situation and the evidence that exists?
Lord, my submission is that this is precisely what is discouraged by the primary legislation, and that is the fourth and fifth point that I wanted to make. So the system, and that I mean, I can.
Well, if you're, as it were, going to cross this ground,
yes,
and reassure me, then please do it in your own way. But it does seem like a pretty bad system.
Yes. So I've made my third point.
Yes.
I have referred my lords to Adebayo and what it says. So my fourth point, my lord, will answer the concern that you have just expressed. And the fourth point, my lord, is that the general scheme of the primary legislation concerning immigration appeals is to discourage successive appeal proceedings. And the authority for that proposition, my lord, is the judgment of this court in J.M. Liberia. May I take, my lords, to that judgment, tab 8 of the authorities bundle, to explain what the court said in that case. This is page 172 of the bundle. So the issue in that case was about the jurisdiction of the tribunal to entertain human rights claim in the circumstances where no such claim was made to the Secretary of State. So a person would apply for leave to remain, say as a student. The Secretary of State would refuse the application, and there is then an appeal against that decision to the tribunal. The question before the court was whether in that appeal an appellant is entitled to raise something new that wasn't raised before the Secretary of State, namely a human rights claim. And if I may ask my lords to look at paragraph 23 of the judgment. Now you'll see that paragraph 23 Lord Justice Laws says that it is clear that legislation leans in favor of what are called one-stop appeals.
I'm sorry, where is that?
This is paragraph 23 of the judgment, page 176. Now, when I will make my submissions on the facts, I'll show my lords that in this case, too, the Secretary of State had issued a one-stop notice. And you will see a reference to sections 96 and 120 of the 2002 Act. So the scheme, and it's clear from paragraph 23, is that there is going to be one appeal. And in that single appeal, the appellant is required to put forward all the reasons on which he seeks to rely on. And if he fails to mention something in that appeal on which he relies subsequently, he will lose the right of appeal. And in that context, it was said that the legislation leans in favor of one-stop appeals. Successive appeals are discouraged by legislation, the point that my lord had in mind. If one follows the point that my lord has in mind, then that surely would lead to successive appeals. There will be an appeal, a favorable decision, an unfavorable decision by the Secretary of State, another appeal, and so on. That is precisely what the legislation discourages. And my lord, this particular paragraph, paragraph 23, was subject of some discussion in another authority, and that authority is for the proposition of the final point that I wanted to make, which is that the system of immigration appeals is designed to avoid, I emphasize, the word discourage was used in JM, avoid is used in the next authority, to avoid multiplicity of appeals and applications. And that objective is achieved by requiring the parties to put forward all their grounds and evidence in one set of proceedings. And the tribunal is placed under a corresponding duty to consider all those issues in one set of proceedings. And the authority, this is the final authority, my lord, that I'll take you to. It's AS Afghanistan. It's behind tab 9 of the bundle. This is the authority where there is detailed and extensive discussion about the nature and ambit of the so-called one-stop appeals, what is meant by the phrase, what the legislation states. Lady Justice Harden gave a dissenting judgment. Lord Justice Mobick and Lord Justice Sullivan allowed that appeal. So that was a case where the appellants had applied for leave to remain under Category X. The Secretary of State had refused that application. On appeal to the tribunal, for the first time, they submitted that they also meet the requirement of Category Y in the immigration rules. And the issue before the court was whether the tribunal is obliged to consider the appeal by reference to Category Y, or the tribunal should simply decide the appeal by reference to Category X and leave the appellant to make a fresh application, as my lord had in mind, resulting in another decision by the Secretary of State. So may I simply, it's a lengthy judgment, may I simply show the paragraphs that are relevant, if I may take my lords to page 203 of the bundle, paragraph 78. This is the judgment of Lord Justice Mobick. You'll see a reference to one-stop appeal, one-stop process in that paragraph. And again, a reference to section 96 and 120. Those are the provisions referred by Lord Justice Laws in JM. And you'll see that Lord Justice Mobick says that, well, they are part of a procedure designed to avoid multiplicity of applications and appeals. First sentence at page 204. And he explains the reasons for that at paragraph 80. And this, I show my lords this judgment to answer a point that my learned friend makes, that the appellant adduced new evidence before Judge White, before Judge Randall, for the first time. If you look at paragraph 80 of the judgment, this is where Lord Justice Mobick discusses section 120 and 96 of the 2002 Act. And if you look at the passage, and you see that he accurately summarizes the effect of the scheme, namely that when the Secretary of State issues a one-stop notice under Section 120, as was issued in this case, she's asking the appellant to put forward everything that she has. And if you look against letter E, Lawrence and Mobic says that that covers not only additional evidence or material supporting the original grounds, but also new grounds. So there's no question that that additional evidence and material supporting the original grounds can be submitted. In fact, that is what the statute requires, what the Secretary of State requires. And the final paragraph that I'll highlight is paragraph 81, that the scheme is that an appellant is required to put forward everything in one set of proceedings, and the tribunal is placed under a duty to consider them in a single appeal, so that there isn't another appeal or another decision.
You said that what Lord Justice Mobic said in paragraph 80 was that it can go beyond additional evidence to new grounds.
Yes.
What I read him as saying is that what the statute contemplates is that the statement under Section 120 will generally contain new grounds rather than additional evidence supporting the original grounds.
Yes.
He's not saying you can do both. He's saying what Section 120 is directed at is fresh grounds.
Absolutely. I mean, he said that because
those were the facts in that case.
Yes,
the issue in that case.
The Secretary of State was arguing that only additional evidence relevant to the original grounds can be adduced. The appellants argued that no, it can be other grounds, and Lawrence and Mobic said, well, it's not simply evidence about the original ground, but also the new grounds. But
this is a decision on the ambit and effect of specific statutory provisions directed at requiring the appellant to put forward their entire case.
I accept that.
Yes.
But
what is the application to the present case? Your point is that it was right that the appellant produced all the evidence.
yes, absolutely, and the Secretary of State also had every opportunity to adduce the evidence that she had, or she could have obtained with reasonable diligence before Judge Randall, and that the failure to do so means that she cannot now come up with new evidence to impugn the findings.
Would it be right to understand that really your points 4 and 5 are rather in the nature of footnotes to your main propositions, as establishing that there's a general tendency towards getting it all done at one time. But as we know in this field, repeated applications from all directions are endemic. I mean, applicants wouldn't be wishing to transpose these sort of remarks from these cases against themselves. I just don't particularly see points 4 and 5 as being fundamental to your case. They're just a sort of contextual
Yes.
submission, are they not?
My Lord, I mean, I see the concern that my Lord has for the applicants. I mean,
No, I'm not expressing a concluded view, obviously, but I'm just trying to see how where you place the weight of your case. I mean, if you say it's a 5-legged stool and they're all important, we'll treat it as that. But if it's really that 4 and 5 are decorations to your 3-legged stool, then that certainly at the moment makes sense to me.
Lord, I've no desire to make the task difficult for the court, but I do submit that quite apart from the principle of finality of litigation, there is also a principle that multiple applications and appeals are discouraged, and that has a role to play in my respective submission in deciding.
Very well.
Whether it be apart from the earlier findings. And just to address the concern that my Lord has just expressed, namely the implications for the applicants of the argument that I've just made, Lady Justice Andrews, in the case of Adebayo, had the same concern. And in the paragraph that I showed, my lord, in the second part of that paragraph, Lady Justice Andrews, and I'll give you the reference again, referred to paragraph 353 of the immigration rules and took the view that that settles that concerns. So that rule, as my lord would know, is about the fresh claims. So if an appellant, after an unsuccessful human rights appeal, comes up with new evidence, and that new evidence is significantly different from the material that was considered previously, and if there's a realistic prospect of success, that would be a fresh claim giving rise to a fresh appeal. Devasaline would apply. So Lady Justice Andrew said, this is paragraph 46, last two sentences of that paragraph, that, this is mitigated, that the general point is mitigated in relation to the applicants in that scenario. So, my lord, these are the 5 points that I make, and invite my lords to consider the decisions made below by reference to these 5 points. Now, addressing very briefly the court on the decisions made below. Firstly, if I may take my lords to page 102 of the appeal bundle. This is, I ought to clarify, is not the bundle prepared by the court, but a bundle that was prepared by my instructing solicitors. It has 123 pages.
So we're here in the first decision, are we?
Yes. The decision of 22nd of April 2015 responds to an application, as my lords will see, made on 12th of December 2012. Under the heading General Grounds, Reasons for Refusal, the Secretary of State says that Bark Bank documents were false. No evidence is cited, but the Secretary of State does not explain why that is so, apart from saying that, well, we have sought to verify those documents. The Secretary of State does not disclose at that stage the evidence that she had. It's quite normal in these sort of proceedings. The Secretary of State
It's not particularized, and it's not even littered.
No.
Yes.
So that's what the allegation is. Now, if you go to page 105 of the bundle, you'll see a one-stop warning. So this relates to...
Page again, please.
Page 105 of the bundle. This is the same decision.
Yes.
One-stop warning. So this relates to sections 96 and 120, what was referred in JM and ASF. The Secretary of State said, well, if you have anything that you want to tell us now. If you don't disclose something that you later rely on, then you may not be able to appeal against that decision. And there's an ongoing requirement to put forward everything that you want to rely on at the appeal proceedings. The appeal decision...
Mr. Barrett, we don't, I think, have the immigration rules, but paragraph 322(1)(a) is an overarching general ground for refusing an application on the basis that false documents have been submitted
Yes.
with the application.
Yes.
And that's all that the Secretary of State needs to consider. If the Secretary of State concludes that false documents have been submitted, then she is entitled to refuse the application on that ground alone. Is that correct?
That is correct. And
Is she entitled or obliged to refuse it?
She's obliged to refuse the application because the rule is mandatory. It says that an application must be refused, should be refused, or must be refused.
Could we just pause on this document to see exactly what is and what isn't being decided by it? As you say, page 102, false refusal under paragraph 3221A, and then on the following page we have a point scoring exercise.
Yes.
In which points are awarded, but your client comes to grief on the financial
yes.
issue. And then underneath that, we have not carried out an assessment
Yes.
of your application as it's been refused. And that's on page 104.
Yes. Yes.
So that is in between the original decision and the one-stop order.
Yes. So the reason for that, my lord, is that even if the documents are genuine, and even if a person has funds in the account, the Secretary of State can still refuse the application under 245DD, I and H that are referred, if she suspects that the appellant is not a genuine entrepreneur. He has asked a friend to put money in the account simply to make an application.
Or it might be that there is a genuine account, but there isn't enough money in it, or something of that sort.
Yes. Or the business that the appellant is running is a shame, and so on and so forth. So the Secretary of State is saying, well, you submitted false documents, full stop, and I'm not going to go beyond and interview you as to what you've done.
So that's that decision.
That's that decision. So the appeal against that decision came before Judge Randall. You have that decision at page 94. You'll see, my lords, that the appeal was heard on 11th of December 2015. The date is important. Both parties were represented. Paragraph 5.2, the burden of proof was on the Secretary of State. No dispute about that. Now you will then see two headings, respondent's bundle and appellant's bundle. So the Secretary of State in the decision letter said nothing about the evidence, which is quite normal. Under the procedure rules, within 28 days of receiving the notice of appeal, the Secretary of State is obliged to file a bundle of documents with all the evidence on which he seeks to rely on. So you will see that pursuant to that rule, the Secretary of State files a respondent's bundle, and that bundle contains all the documents on which the Secretary of State seeks to rely on, including the outcome of the verification checks. You'll then see a heading, the appellant's bundle. Now again, under the procedure rules, the appellant is required to file a bundle in advance of the hearing. Presently, an appellant is required to file a bundle within 28 days of the service of the respondent's bundle. But way back in 2015, my recollection is that the appellant was required to file the bundle at least 5 days before the hearing. But the point is that it's not that the appellant simply submits documents to the tribunal at the hearing for the first time. The appellant files a bundle in advance of the hearing, serves that bundle on the respondent so that the respondent can prepare. Now, the hearing was on 11th of December, as I submitted. So paragraph 7.2, within the appellant's bundle, the appellant had a witness statement and 2 letters dated November.
Just remind us, when was the appellant's bundle filed?
My lord, unfortunately, I do not have the date. I did try to ascertain the date. The appellant was represented by different solicitors. My solicitors do not have the actual file. But what one can conclude with confidence that it was filed in accordance with whatever directions that the tribunal has given.
Because there's no adverse comment.
There's no adverse comment, no. So the fact that the appellant had provided evidence in the form of witness statements and exhibits is not surprising at all, because that was the whole point of submitting the appellant's bundle. The appellant received the Secretary of State's evidence in the respondent's bundle, compiled this bundle, provides witness statements and provides evidence. And in fact, this is what he was required, obliged to do so by the statutory scheme, to put forward everything that was submitted.
This is a peculiar procedure that applies, does it, in the immigration tribunal context? Because normally in civil litigation, producing bundles consists of producing, as it were, an accumulation of material that has already been disclosed as between the parties. Your account to us is that you can have a decision-making process, and then it all starts up again as soon as a decision is taken and an appeal is lodged. That the Secretary of State then produces anything and everything, and the appellant then produces anything and everything?
Well,
regardless of whether it was available to the decision maker in the first place?
Absolutely, yes. That is what the...
So really the Secretary of State's decision on this account is really no more than practice swing for the real event in the tribunal.
Yes, the tribunal is effectively the primary decision maker. The tribunal becomes the primary decision maker, and can take into account further evidence. That's well settled in asylum jurisdiction, even in immigration jurisdiction. It's well settled. It is of course subject to certain limitations, and the system has now changed. But at that point,
So if the system has now changed, in what way? That you have to get your materials before the original decision maker,
yes,
and the original decision maker has to give reasons in a fuller sense?
yes. So the procedure now is that if a person seeks to rely on something that wasn't submitted to the respondent, then the tribunal requires the respondent's consent before the tribunal can consider the new
When did
matter.
these changes, broadly speaking,
Well,
have effect?
they came into effect by the Immigration Act 2014 in April 2015. They do not apply to this particular case because this case is subject to complex transitional provisions because the application for leave to remain was made way back in 2012, and for that reason, the old provisions apply to the present
Right,
case.
so you say the procedural landscape might have been quite different had it been a slightly later application, appeal that was being considered.
Yeah, it might have been different.
So if all of this had been happening last year, say, then when the appellant produced the letters that the Secretary of State had not seen before, what could the Secretary of State have done?
Yes. My apologies again. So the new statutory scheme is that if a person wants to rely on a matter that wasn't submitted to the Secretary of State, was not subject to the decision made by the tribunal, made by the Secretary of State, then the tribunal needs the Secretary of State's consent before the tribunal can consider the new matter. Now there is an issue, and I'm aware of proceedings elsewhere, as to what actually amounts to a new matter in that context, whether it's evidence or whether it's reliance on something new. So it's possible. I'm so very sorry for not being clear, but I mean I do not want to make a submission that if it was happening this year or last year, the tribunal will require the Secretary of State's consent to consider this, because there may well be an issue about what actually means by the new matter. But all that does not arise in this case, because in this case, as I will show, my lords, it's well settled that the tribunal was entitled to entertain new evidence and to make findings on that evidence. So, my lords, so you have seen the reference to the appellant's bundle, the respondent's bundle. If you then look at the heading, the hearing, at page 98. So a notice of hearing was sent to the parties on 4th of November. So this was, and the hearing was 11th of December, good 6 weeks before the hearing took place. Both sides had ample opportunity to consider the evidence filed by each other and to prepare for the hearing. Now you'll see that it was the appellant who had applied for adjournment on the basis that she was not well. Now, if the respondent needed more time, the respondent to consider this evidence or to conduct verification checks, she could have agreed to the adjournment application, or she could have applied for adjournment. But see paragraph 12. Miss Bell for the Secretary of State, in fact, opposed the application made by the appellant to adjourn. She did not say that, well, she needed more time to consider the appellant's evidence, or that further checks are required. She was content to proceed because she had the bundle and the evidence in her possession. If you look at the heading submissions, you'll see that Ms. Bell for the Secretary of State not only took no objection as to the appellant's bundle, but made submissions on the new documents provided by the appellant.
Sorry, where are we now?
Paragraph 15 under the heading submissions.
15. Thank you.
So Ms. Bell for the Secretary of State said, well, that the Secretary of State's evidence is good enough to discharge the burden of proof, and the evidence adduced by the appellant isn't good enough. She referred to the new evidence provided by the appellant and made submissions. So it's not a case, and I say this with great respect, as Miller and Friends skeleton suggests, that, well, these documents were provided to the tribunal alone and not to the Secretary of State. That isn't the case. They were provided to the Secretary of State. The Secretary of State had all the opportunity to consider it. If she was short of time, she could have asked the tribunal for further time. So she was content and considered the letter and made submissions and asked the judge to dismiss the appeal. Now, if you then look at paragraph 18, the judge asked particular questions about the respondent's evidence because she had the burden of proof, asked why the emails were redacted, the emails adduced by the Secretary of State. There's no answer to that. The further questions about the gaps in the respondent's evidence, Ms. Bell was not able to assist. She didn't ask for further time. Now, if you then look at the determination and reasons, page 100, and if you look at paragraph 22, this answers the point that Millard had in mind. So this appeal, in that sort of appeal, it was entirely open to the appellant to submit further evidence.
Your paragraph?
Paragraph 22.
22, thank you.
There are circumstances in which submission of further evidence is simply not possible. Even at that time, for example, where a person was seeking to adduce evidence to demonstrate that he meets the requirements of the rules, he's entitled to certain points, for example. Even at that time, it wasn't open to the appellant to submit further evidence. But when the issue is about deception and genuineness of bank statements, then both sides were entitled, in fact, obliged to provide all the evidence. This is paragraph 22. There's no issue about that. Now, the reasons given by the judge in my submission are in two parts. The first part is paragraphs 23 to 26. This is where the judge exclusively addresses the respondent's evidence because the respondent had the burden. And the judge considered the respondent's evidence carefully, he says, and then identifies the reasons as to why there were significant gaps in that evidence, significant doubts as to what the Secretary of State had said. And the reasons given by the judge in my respectful submission are good reasons. The Secretary of State took no issue with those reasons. So that's the first part. If you look at paragraph 26, you will see the conclusion. I'm not satisfied as to which documents were shown to the Bark Bank in the initial inquiry and so on and so forth. So that's the first part. The judge expresses significant doubts about the respondent's evidence. From 27 to 30, the judge then considers the appellant's evidence. And within that, at paragraph 20, again refers to the respondent's evidence that the request made by the Secretary of State, the entry clearance officer, was not well phrased. It wasn't accurate. There's a reference to random samples of 5 documents. And the judge took the view that in all the circumstances, the respondent had not discharged the burden of proof. And the judge allowed the appeal. Now, the Secretary of State had a right of appeal from that decision to the upper tribunal.
Can I just, looking at paragraph 30,
Yes.
the judge, on the face of it, said it's burden on the Secretary of State. In the light of the new evidence, which presumably was the 24th of November letters, the Secretary of State has not overcome that burden of proof. So the judge was very much relying on the letters, was he not?
Well, he was. I cannot pretend that he wasn't. But I do ask my lords to look at the first sentence of paragraph 30 as well, which provides the context to the second sentence, that the judge was concerned about the defects in the Secretary of State's evidence, about the absence of a paper trail where documents were submitted. But of course, the judge also relied on the evidence adduced by the appellant. The appellant was entitled to put forward the new evidence. The Secretary of State had that evidence, every opportunity to verify those documents, to ask the judge for further time. the judge allows the appeal. The Secretary of State had a right of appeal to the upper tribunal to be exercised with permission. She could have appealed to the upper tribunal saying that, well, the judge got it wrong. The reasons given by the judge at 23 and 26 were not justified. The appellant's evidence was fraudulent. If she took that view. But of course, even in that appeal, she had to meet Ladd and Marshall test in order to rely on any new evidence. But she decided not to appeal against this decision. She decided not to ask the tribunal to reopen these proceedings. She remade the decision, in my submission, effectively changing the date of the decision. So the new decision is the second decision is at page 88 of the bundle.
Well, we're just looking, are we not, at the end of the first decision at 101. The appeal was allowed, and it was for the respondent to decide on the substantive PBS
Yes.
application.
So that, my lord, is the usual course of action that the tribunal would take. If the issue is about deception, the tribunal would decide that issue.
Yes, but what the tribunal has decided here is that the Secretary of State has failed to the requisite standard to show that what your client first produced was a fake.
Yes.
The Secretary of State's been told to go away and decide the substantive application. One of the things the Secretary of State's got to decide on the substantive application, as I understand it, is access to funds. I mean, you can't, can you, use this decision as if it was cash in the bank?
Lord, if you look at the first sentence of paragraph 31, the respondent states in the refusal letter that other elements of the rules have not been considered. So yes, the Secretary of State will obviously consider
yes, I mean, this seems to me to be potentially very important in relation to this appeal. I mean, you seek to persuade us, as I understand it, that effectively this is the golden token,
yes.
Which effectively bypasses access to funds. And that the Secretary of State, when going back and doing what she was told to do, which was to decide the substantive application, wasn't entitled to look into the question of access to funds.
Oh, no, I don't.
Is that not what it amounts to?
No, I don't submit that.
Right, so in that case, when the Secretary of State goes back, and I'm sorry, I'll stop talking and let you make your response, but when the Secretary of State has to go back and decide the substantive application, she has to go down the qualifying criteria and decide whether they're met. Is that not so?
Yes, but may I show, my lord, the next decision to show my lord as to what she did? Would
you like to just tell us what's the point, though, before you...
Well, no. She made the same decision as she made previously. She said that you submitted false BARC bank documents, and for that reason, Rule 3221A applies, and I refuse your application. I'm not going to conduct that assessment at all about under paragraph 245DD of the immigration rules. I'm not going to look at the genuineness of the business or whether the substantive requirements are met. I'm going to knock you down
so is it
again at that point.
Drawing the point more narrowly, is it your suggestion that any question of genuineness of documents is, as of the 20th of January 2016, off the table?
Well, for the purpose of paragraph 3221A of the immigration rules, the rule that was an issue, so the tribunal decided that the documents were not false, but it is open to the Secretary of State to refuse the application on the basis that the documents are genuine, but I'm not satisfied that you're a genuine entrepreneur. You may have taken funds from a relative or friend. You're not running a genuine
business. So the issue of the genuineness of any document that had by then been produced by the applicant is, in your submission, not open to question.
No, not any document, but the bank statements, the bank documents in particular.
That's what I meant.
That absolutely, that is the submission that I make.
What about the letters, which it was not suggested at the first tribunal hearing had been the subject of any verification process.
Well, in the second decision, may I perhaps just show you the second decision just to answer the point? You'll see that the Secretary of State again said that in your application, namely with the application submitted in 2012, you submitted false documents.
Yeah, well, I follow that, but I want you to sort of stand back and look at the real world.
Yes.
If the Secretary of State says, right, now then, I've lost in the First Tier Tribunal, but in the First Tier Tribunal, some letters were produced relatively shortly beforehand. I, as a matter of fact, haven't verified them. If they now turn out to be bogus, is the Secretary of State meant to just ignore that?
No. The Secretary of State will go to the tribunal, and the tribunal will consider whether she had a good reason for not conducting the verification checks earlier. That's whether, even with reasonable diligence, she could not have verified those documents. Why the Secretary of State did not do what she has done now in the first appeal. If there is a good reason, the second tribunal would depart from the first decision. If there isn't a good reason, then the second tribunal will treat the first decision as determinative. The second tribunal will also ask the Secretary of State that, well, firstly, why you did not do earlier what you have done now, and secondly, why did you not appeal against the first decision to the upper tribunal? You had a right of appeal. You could have argued at the upper tribunal that the first judge was wrong. But what you can't do is to come to the second tribunal without giving any reasons as to why you haven't done earlier what you have done now and why you did not appeal, and ask the second judge to simply depart from the first decision. So it all depends on whether there is a very good reason to use the phrase used by the upper tribunal in Mugu and by the Court of Appeal in BK, or Ladin-Marshall test, whether the new evidence could have been submitted earlier.
Can I be sure I understand what you say should have happened? You referred to the Secretary of State going to the second tribunal. Is that on an appeal against a second decision? Or is it something initiated by the Secretary of State? What was the procedure that should have been adopted in my Lord's example, where the Secretary of State, subsequent to the first decision, obtains evidence that
Yes.
the November letters were false?
Yes.
What should have happened in your submission?
Well, the Secretary of State should have appealed against the first decision to the upper tribunal.
Out of time?
Out of time, yes. For explaining...
Is she obliged to exercise a right of appeal if she's obtained evidence that the November letters are false?
She's not obliged to appeal, but if she takes the view that the new evidence demonstrates that the first decision was wrong, then she has a right of appeal to the upper tribunal. And I do invite lords to consider the proposition in the reverse order. I mean, what if the tribunal had decided the point, the first judge had decided the point in the Secretary of State's favor against the appellant? The Secretary of State would have been arguing that, well, that's the end of the matter. If the appellant had adduced further evidence, well, why did the appellant not adduce that evidence earlier? If the appellant got hold of the evidence suggesting that the first decision was wrong, why did he not appeal? And this, in my respectful submission, if the court endorses the Secretary of State's position, it's an endless cycle that will never end. Just assume that in this case, the second judge, Judge White, had again decided the issue in favor of the appellant. If you accept Mullen's friend's proposition, the Secretary of State can then embark on another investigation and to demonstrate that, well, the evidence adduced by the appellant was false, and to remake another decision, and then another, and then another. So this will never end on the Secretary of State's proposition, and for that reason, those are good reasons why this court insisted on introducing Ladin-Marshall test, even in this context, that the decision maker had to provide a reason as to why the evidence wasn't adduced earlier. So if you look at the second decision, just to see what the Secretary of State did, this is page 88 of the bundle, and Lords will see that the Secretary of State has effectively changed the date of the decision. The decision is now 4th of August 2016. The Secretary of State again refuses the application under Rule 3221A, again says, this is the point that Mullard had in mind, this is page 90, that the relevant requirements are not met because false documents were provided, and again gives a one-stop warning and effectively makes a second decision as if Judge Randall had not promulgated the decision on the issue. So what was the point having the hearing before Judge Randall if the Secretary of State is able to circumvent the appeal decision in this manner? And as I made a point in my skeleton, that endorsing the Secretary of State's case can actually lead to the parties assuming that they can come to the tribunal half prepared, and they can always tailor their evidence after receiving a unfavorable decision and do good the defects earlier. So the appellant, left with no other option, brings another appeal to the tribunal. That appeal comes before Judge White. His decision is at page 80.
What, if anything, is the significance of the fact that on page 104, which is the first decision, there is a rubric about we have not carried out an assessment as detailed in paragraph 245 D. So there's that rubric. Does that appear in the second decision? I mean, I asked the question because I don't think it does,
no,
and I just wondered what the significance was.
No, and my submission is that there's no significance of that because the Secretary of State clearly had refused the application under Rule 3221A. She hasn't said, for example, that, well, you know, I accept the decision made by Judge Randall, but I refuse your application because you're not a genuine entrepreneur. You're running a fraudulent business, for instance. So she makes effectively the same decision without using that particular phrase. So Judge White's decision starts on page 80 of the bundle. So the Secretary of State, as is common ground, conducts further verification checks, obtains further evidence, provides that evidence to Judge White. If you look at paragraph 8 of Judge White's decision, page 83 of the bundle, Judge White said that no submissions were made as to the precise effect of the first decision. I said I accept in fairness to Judge White that he did not receive the assistance that he should have received from the representatives. His attention, it appears, was not drawn to the case law. But that, with respect, is no defense because Judge White is a specialist tribunal, ought to have been aware of the law. If the Judge White got the law wrong, then it's no defense that the law was not brought to his attention.
Well, do you have any fundamental problem with his self-direction in paragraph 8?
Absolutely, yes, because the judge has got the test wrong. The judge says that in absence of cogent further evidence, I should not allow relitigation. That is not the test. The test is whether further evidence ought to have been or could have been with reasonable diligence adduced earlier. That in Marshall test, the judge got the test wrong. No consideration whatsoever of the principle of finality in litigation and the principle behind res judicata, no consideration of the one-stop system of immigration appeals, and the fact that this approach effectively results in successive appeals. So paragraph 8, the judge gets the test wrong, fails to take into account relevant matters. And this submission is reinforced by what the judge said towards the end of his decision at paragraph 17. This is at page 85. If you look at the last sentence of page 85, the judge says that there is new evidence, and on the basis of new evidence, that the new evidence justifies me in revisiting Judge Randall's conclusion and reaching my own decision. The judge is proceeding on the basis that if either party adduces further evidence, the judge can forget about the first decision and can allow relitigation. That's not the test. The test is Laird and Marshall, why the Secretary of State did not conduct these checks earlier, why the evidence was not produced earlier, why it could not have been produced with reasonable diligence, why she did not appeal to the upper tribunal against the first decision. So no questions. The judge simply proceeds on the basis that the new evidence justifies departure from the earlier findings. That plainly is the wrong test. So, Lord, this is the decision by Judge White. The simple submission is that Judge White applied the wrong test. On the correct test, Laird and Marshall, it wasn't open to Judge White to depart from the earlier decision. And finally, the upper tribunal's decision is at page 49 of the bundle. And may I take my lord straight to the actual reasoning. If you look at page 54 of the bundle, the first reason given by the judge is at 64. In the second sentence, third sentence in particular, the respondent had no opportunity to verify these letters. These were the new letters that were provided to Judge White.
You're in paragraph
26.
Thank you.
Third line, the respondent has no opportunity to verify these letters. This is with respect is simply wrong, because the respondent had every opportunity to verify those letters. She had the appellant's bundle. If she wanted more time, she could have asked the judge to adjourn, to agree to the appellant's application. So that, with respect, is simply a point that is wrong. Then, if you look at paragraph 28, third line, well, this was not a case where the respondent was attempting to circumvent the decision of Judge Randall. Clearly, the Secretary of State was attempting to circumvent the decision of Judge Randall. The principles in Laird and Marshall did not apply. That, with respect, is again wrong in law, because on the binding authority, Laird and Marshall principle applies. And those principles did prevent the Secretary of State from obtaining further evidence and relying on that evidence unless there was a good reason as to why that evidence wasn't adduced earlier. And then what the judge said at paragraph 29 with respect again is a miscategorization of the appellant's case. The second sentence, it was not in dispute that the Secretary of State can impugn a previous decision on the basis of fresh evidence, which was not previously available.
Of fraud.
A fraud, which was not previously available. Well, that of course was an issue in dispute, and that was what I was arguing, that Laird and Marshall test, the Secretary of State cannot simply rely on new evidence and submit that evidence without meeting Laird and Marshall test. And then the judge says that the Laird and Marshall test is satisfied. It's just impossible to see how that test is satisfied. The judge has not explained how that test is satisfied. Why the Secretary of State could not have obtained this evidence with due diligence at the first hearing. And then the last sentence at paragraph 30. It was not the case that the respondent could, with reasonable diligence, have discovered it earlier. No reasons for that conclusion. apart from what the judge said at paragraph 26, which was wrong, the appellant, the Secretary of State had all the opportunity to adduce this evidence. So for these reasons, I submit with respect that the upper tribunal's decision is wrong in law. And these are my submissions for inviting the court to allow this appeal. So unless I can assist Lords any further, these are my submissions.
Might you say that your submission would gain strength if one was to change the facts in this way? Let's suppose the applicant had put forward the original bank documents. The Secretary of State had refused on the basis of fraudulence, and no other document had been presented by the applicant.
Yes.
Before the hearing. And the appeal had been allowed.
Yes.
And the thing had been sent back for a new decision. Then in those circumstances, you would be entitled to argue that for the Secretary of State to say
Absolutely.
that the documents unsupplemented
Absolutely. Yes.
wouldn't be entitled to say that they were fraudulent.
Yes.
Again, on exactly the same evidence.
Yes. Absolutely. Absolutely. But what's the difference in submitting those documents with the application for leave to remain, or during the appeal proceedings, well in advance of the hearing in the appeal bundle?
Yes. Well, in this case, we're slightly handicapped by the fact that we don't know exactly when the appellant's bundle was provided, but you say you fairly make the point that there isn't a kerfuffle about that.
And Miller Trend
at the hearing. Yes,
and Miller Trend does not suggest. Yes, it's actually a submission by Miller Trend that those documents were submitted to the tribunal alone, but that submission with respect.
Well, the letters are dated the 24th of November. It's you're not able to help us as to when they were disclosed to anybody. And could you remind us of the date of the hearing before Judge?
11th of December. So you have the 2 points. I'm sure that I make in response to that. Firstly, one can assume with confidence that the bundle was filed in accordance with the directions given by the tribunal.
Right. So,
I'm sorry to interrupt. When you say the directions, do you mean standard directions?
Standard directions, yes.
Which I've written down at the time. Your recollection is 5 days before the hearing.
Yes. Exactly. Yes.
So.
And your junior, who presumably practices in the same field, nods. Yes.
Yes.
So the way it goes is that you put in a document, you're told it's not genuine, you appeal, and then, provided you're not later than 5 days before the hearing date, whenever that might be in those days, you put in a whole lot of new documents. And at that point, the only remedy for the Secretary of State, if she's not to fall foul of your submission, is to apply for an adjournment.
Yes, if she had not enough time to look at those documents to make submissions.
Well, I might suppose that 5 days isn't sufficient to do a proper job.
What has happened here happens in this jurisdiction with frequency. In asylum cases, for example, the Secretary of State makes a decision. The appellant comes up with a whole lot of new evidence for the first time at the tribunal. The Secretary of State looks at it. If she is content to proceed, she won't apply for adjournment, or if there is enough time to conduct verification checks, she would do that.
So you say here the Secretary of State rolled the dice in the hope that she was going to
win, yes,
to fend off the appeal, and she lost.
Yes, that is the decision that the Secretary of State took.
And as we're in a situation now, with the benefit of hindsight, where we've had repeated finding that these documents are false, a finding that's not appealed.
It's not appealed, yes.
You say that that's just tough for the system to work properly, people who produce false documents may get the benefit of it.
No, I'm not conceding, obviously, that the documents were false.
No, there's a finding. There's a finding.
There is, but there is, of course, a parallel finding that documents were not false. The unchallenged findings, which
No, I think you misunderstood. Judge White looked at a lot of documents and came to the clear finding they were all false.
yes,
Documents which
Yes,
Judge
I
Randall
accept
never
that.
saw.
yes, I accept that. Yes,
Yes.
but the question, of course, is whether the judge was entitled to
Yes.
conduct
Well,
that.
you say
exercise.
you say that a court that went into it in great detail and reached a conclusion that there had been successive fraudulent attempts to gain immigration status was simply not entitled to do that for the procedural reasons that you have clearly outlined.
Yes, and
That's what it comes to.
Absolutely, and I just conclude my submissions by saying that, well, what this court will say, of course, will not apply to this case alone. I mean, of course, my lords may take the view that there is a finding that the documents were false, and it wouldn't be appropriate or just to let this appellant go in this manner. But of course, it's more about the general principle of finality of litigation in immigration appeals and where this cycle actually ends. As I submitted, if Judge White had resolved the issue in the appellant's favor, the Secretary of State could have done the same thing again.
Can I ask you two questions? Firstly, can I be sure that I understand where your submissions lead to? Suppose we're persuaded by your submissions
Yes.
and we allow the appeal. All that means is that the second decision and the grounds for the second decision fall away.
Absolutely.
The Secretary of State still has to go through the assessment.
I accept that. Absolutely. And she can.
In that assessment, one of the things she has to be satisfied is that the funds are genuinely available, is it not?
Well, yes, the Secretary of State can refuse the application, not on the ground, not under Rule 3221A on the basis that there was deception, but on the basis that the appellant is not a genuine entrepreneur.
Genuine entrepreneur. Now, is the Secretary of State entitled, in coming to, assume the appeal succeeds, in coming to that conclusion, as to whether, which as I understand is a discretionary ground, not a mandatory
It is,
ground,
absolutely.
as to whether she's satisfied that the applicant is a genuine entrepreneur, is she entitled to take into account her views and Judge White's views of the authenticity of the documents submitted?
Not the views
Not
of Judge
White's
White.
views, but she can form her own view, can she?
Yes, and she can
Including, could she say to herself, well, I know that Judge Randall found these documents are genuine, and I've been told by the Court of Appeal that Judge White shouldn't have gone into that question because it was final. But I, now looking not at the question of deception, but at the question of whether in my discretion I think the applicant is a genuine entrepreneur, can take account of the evidence I have before me
I accept that.
that these documents were false.
Yes, and absolutely. And if she makes that decision, that will trigger another appeal.
It will trigger another appeal.
And then there will be an argument, not about...
It won't be an estoppel argument. It won't be a finality of litigation argument.
No, and there won't be an argument about whether the bank statements were false or genuine. The argument would be whether the appellant is a genuine entrepreneur. The appellant will explain what she has been doing, for example, what she has done.
But you say it's an issue, an issue that is not open to the Secretary of State to revisit.
The issue of false documents.
Yes.
But she's...
The issue of money, the issue of the fund, as evidenced by the documents, you say the Secretary of State can't go back to.
No, the Secretary of State must accept that the bank documents are genuine. They're not false. Someone has not printed them off on their printer. But she can legitimately, if there are good reasons, say that I'm not satisfied that the money in this account is yours. It is someone else's money. I'm not satisfied that you're a genuine entrepreneur, for example, and refuse her on that basis. And if she refuses on that basis, there will be an appeal.
Right.
But the
She's
issue,
not entitled to say the money isn't in the accounts.
You're not entitled to say the bank statement's not genuine.
that's
Because that's the issue you say has been decided.
that's the only point that I make. Yes,
Yeah.
she's not entitled to say that the bank statements are false, but she's entitled to say, if she has good reasons, that the appellant is not a genuine entrepreneur. So if you allow the appeal, effectively Judge Randall's decision will be an effective decision, requiring the Secretary of State to make an assessment as to the other elements of the immigration rules.
That was my first question. My second question was this. You accepted, I think, earlier that in ordinary private law litigation, a judgment that's been obtained by deception can be set aside, and the Supreme Court has told us in Takar and Gracefield that for that application, you don't need to satisfy the Ladd and Marshall. All you need to show is that there was that the court was deceived, and the judgment will then be set aside. And I think you also accepted that it would have been open to the Secretary of State to appeal the first FTT decision to the upper tribunal on the basis that the new evidence, the 24th of November 2015 letters, was, as she now knew, false. Does it follow that if she had taken that course, the appeal to the upper tribunal, she would not have needed to satisfy the Ladd and Marshall test if her ground of appeal was that the FTT, the first FTT, was deceived?
No, my lord. In this jurisdiction, in the tribunal's jurisdiction, if the Secretary of State, if any party wishes to impugn the tribunal's decision on the basis of fresh evidence, Ladd and Marshall test must be met.
Even in a case of fraud? I understand entirely if it's simply, well, you said this and I said that, and now I've got some new evidence which goes to that, so I want to persuade the court that actually the decision was wrong. But as I read Takar and Gracefield, the Supreme Court deprecated the notion that someone who has successfully deceived a court could erect a Ladd and Marshall hurdle before that fraud could be proved in the second time round, either on appeal or in a fresh action. And I think your submission is that it's different in this jurisdiction. Is that right?
It is, because the authorities that I've referred my lords to are the authorities about this particular jurisdiction, and they are clear that it's Ladd and Marshall that applies to appeals to the upper tribunal.
But have any of the authorities you've shown us relating to supposed fraud?
Well, Mobo was a case about fraud, because, and Ulla was a case about fraud.
Not being in the country, claiming to be in the country.
Well, that was BK. Mobo had allegedly submitted a fraudulent birth certificate, originating from a hospital that was built many years after the date on the birth certificate. Ulla was a case where, as my lord said, it was a fraud case. The parent said that he was here, not in the country.
So what applies in private law simply doesn't apply in the immigration tribunals.
That is the submission that I make. Yes, and to be fair, that is not a submission that my learned friend makes. In fact, she says quite properly that the principle applicable in private law do not apply to these proceedings. She has said that repeatedly, correctly in my respective submission in her skeleton.
The principle of what?
That apply in general civil litigation,
Yeah.
do not apply to statutory appeals of this nature. My learned friend has said repeatedly in her skeleton, of course, in a slightly different context.
I understand why you say that that's what the authorities say. Is there any principled reason why, on this particular point, the policy of the law should diverge in this jurisdiction? Because my understanding of what the Supreme Court said in private litigation was it's just wrong that someone who has successfully deceived a court should not suffer
Yes.
that Meaning, once that's proved, it's obviously difficult to prove, but if it is proved, then the consequences follow, and it's not necessary to show you could have discovered the fraud earlier. Once you discover the fraud, you can have the judgment set aside, either on appeal or in a fresh action. As I say, I understand your submission that this is what the authorities you've shown us say, but
Yes.
is there any policy reason why it should be different in this jurisdiction?
My Lord, of course, this is not a case where the Secretary of State appealed to the upper tribunal.
Yes.
If she appeals to the upper tribunal, if I may, with greatest respect and diffidence, respond to the point in this way, if she had appealed to the upper tribunal, or if she appeals, this question would then arise, and the tribunal
it could then be answered on its merits. And you say it doesn't arise in
this case because there isn't an appeal.
Yes.
But if you allow the appeal, I mean, theoretically, it is still open to the Secretary of State to appeal against Judge Rendell's decision to the upper tribunal. Of course, that appeal would be way out of time. But if she provides good reasons for extension of time, that's still an option open to her. And if there was an appeal, or if there is to be an appeal, the upper tribunal will make a reasoned decision on that, and there can then be a discussion, proper discussion about that. But the question does not arise at this stage. Of course, I confess that I'm no expert in civil litigation, so my knowledge of Tucker is quite limited. But that's how I would respectfully respond to the point. I'm grateful.
Thank you very much, Mr. Malik. Yes, Ms. Anderson.
Hello. My submission is one has to be very, very careful to look at what the concerns of the legal principles that have been developed were in order to understand what has been developed and when they apply and why they would make any difference. Because there's no dispute here that the Secretary of State was obliged to make this second decision. The Secretary of State was obliged to make that decision by statute and to make it on the basis of the current available information. So there's no statutory restriction here. And indeed, in public law terms, the public law would say you have to take account of all relevant information. And that's what happened here. And
Could I just ask you to pick up the point I made a moment ago, to ask whether it would make any difference if the November letters hadn't been advanced?
My Lord, can I build that in?
Would you at some point take that?
I have got it noted, my Lord, and I will build that in.
Right, so take account of all the information at the time of making the decision.
So as far as statute and absent all these legal principles that have come in now about land marshal and what have you, if one looks at what the statute requires and what has happened, one would think there isn't a problem here. What we have is the Secretary of State's made a decision. That decision has actually been judicially considered. It's been found to be well-founded on the facts, the law as such, absent these principles, restrictive principles that are now cited, that weren't cited to the First Tier Tribunal judge, and the upper tribunal has considered the arguments now made and has looked at the evidence that was there, and indeed the second time around, the first instance judge had better evidence, and there's no dispute about that. Not only did he not have, the first time around, the judge didn't have the full evidence. There was no question of oral evidence from the applicant, and by applicant I mean the applicant for leave to remain. So, standing back, we have a situation where the Secretary of State has made a decision, it's been reviewed on an appeal against further evidence, and then that's been appealed to the Appellate Tribunal, who's also considered these new points about, well, this should have been off limits to the First Tier Tribunal, and those have been rejected. So one asks, well, what's wrong with that? My learned friend says, what's wrong with it is there's a set of legal principles that say there's a procedural bar. That means that the judge, well, he says there ought to be, if we're taking all the points together, there ought to be raised judicata. So there ought to have been a bar on the Secretary of State really making any decision at all on that issue. If one's properly applying raised show you why that's important in a second. But his second point is, well, if the Secretary of State was going to do this again, the Secretary of State has to apply ladder marshal, or there has to be a ladder marshal procedural hurdle before the Secretary of State can consider this matter again, and before the First Tier Tribunal can consider the further evidence and the issue again. So there's sort of two submissions there. And the case law that's used in my submission is the case law that belongs to the type of abuse, which is the Secretary of State making a decision at all on the matter, because it's based on the res judicata idea and re-litigation. And so the abuse lies in making another decision at all. Somebody won their appeal, they're entitled to ILR, they're getting on with their life, and then the Secretary of State comes along with a new decision, revokes ILR, or does something which cuts across something that was final in litigation, something that was settled. And so the question is, can it be reopened? And in fact, the answer in that context is not. The Secretary of State's got to go back and appeal whichever judicial decision was the problem. In fact, the answer is, ladder marshal means you can, as long as you're within your statutory powers, you can, in fact, there is no abuse if you look at this again on the basis of new evidence and new information. So it's not even res judicata in the very strict sense, or that is completely sealed off by litigation without reopening the litigation. And with respect, that's where my learned friend gets in a little bit of a knot, because there just isn't a principle that says you have to go back and reopen the appeal. The principle is, if the Secretary of State is going to make another decision on the same ground as the judicial decision that's previously been made, you don't have to unpick the judicial decision, because the Secretary of State has got power to make the decision that she's making. The question is, how do you treat the previous judicial decision? And in my submission, the abuse there is making a second decision. What's happening here is something different. This is Refusal, and the tribunal was quite right to look at it. And in Refusal, the question is the same question in the sense of what you do with the first judicial decision. You don't ignore it completely, as my learned friend indicated, that if his submissions on ladder marshal weren't accepted, and the sort of idea that the Secretary of State ought to have appealed the first, instead of accepting remittal, the Secretary of State ought to have done this rather strange appeal of saying, well, I consider myself so restricted by that first decision that I've got to get rid of the First Tier Tribunal decision before I can even look at this case properly on the application and the evidence and what have you. And the Secretary of State didn't consider, quite rightly in my submission, that there was a sort of procedural restriction that came back with the remitted appeal for two reasons. One, it doesn't work in principle because this was a remitted appeal, so we don't have a final judicial decision that you have to reopen to be able to consider the application. And secondly, because the terms of Judge Randall's decisions were not the type of terms that set up a barrier. What he said is there's not enough before me at the moment to meet a high standard of proof. So the original decision, the offensive original decision, as it were, goes away, and so something is gained by the appeal because the applicant isn't fixed with that first decision that the judge is not sure about, but he remits it to be considered so that it can be looked at in the light of all the material available at the time of decision, as the law obliges the Secretary of State to do. The judge doesn't put any restrictions on the appeal. It's not, there used to be a procedure where the judge could give a direction, and the judge would say, I look at this again and I direct this, this and this, as it were. But there's no direction here under because these are the very old rules, and that matters procedurally when we come to what happens next.
Would it have been open to the judge under either old rules or later rules to have hived off an issue, to have carved out an issue when remitting?
I mean, he certainly, if he had done that, it would have raised the question immediately as to whether he could do that.
Right, and so there's no, you don't say there's an easy answer to that.
No. I think the easy answer is actually the judge didn't have power to do it under the statutory appeal powers. But his judgment on the papers would have been given respect, as it So it's not necessary, I think, for him to hermetically seal an issue and say, Secretary of State, you can't look at this. Because
But
the
he
Secretary
could
of
say,
State would be bound.
having gone into this to the extent that I have, I would not expect the Secretary of State to re-enter this particular part of the case.
Yes, I mean, I think what he might more do is, if the Secretary of State's got to enter it, but the Secretary of State's not going to take a different approach, as it were, and as a matter of public law, but also the Secretary of State would, as a matter of respect for judicial decisions, would take account of what the judge found, as it were. So the Secretary of
So
State,
whether or not there's any formal carve-out power, there's certainly an ability to influence and shape the future course of the case.
absolutely, and of course the first thing that would be said on an appeal, if the Secretary of State ignored that completely, would be to say, well, look, there's a public law error here to start off with, because under these old appeal rules, and this ties in with another point I wish to make. Under these appeal rules, if you say this has been gone about in the wrong way by the Secretary of State, then there was an appeal ground of not in accordance with the law. And that's what, in my submission, if you were going to make this argument my learned friend now argues, that the Secretary of State just could not consider this, then it should have been an appeal on that ground, that this decision was not in accordance with the law. Because what my learned friend is relying on is the res judicata authorities. And those are the authorities like TB, Sarabel, the ones that say it was an abuse to make this decision again. You know, it's not good enough for the Secretary of State just to make a decision again because she can. She has to satisfy Ladder Marshall before exercising that statutory discretion, if that's the way of doing it, to make the type of decision that was made. So whether it's a deportation order to someone who's established that they've got a right to remain, and therefore the Secretary of State relies on something where it should have been done earlier. Because if one looks at TB and Sarabel, that line of authority, the abuse there is that the Secretary of State didn't put her full case at the time, she lost, and then she put the other points that she could have put and should have put, because they were all part of the same question. Is this person entitled to asylum? Well, if they're somebody who should be excluded from the protection of the Convention, or there's somebody who's committed a serious crime and therefore isn't entitled, and so there's a different treatment. The argument in those cases which succeeded was the Secretary of State's obliged to put all her cards on the table, as it were, and if she could have brought those arguments about the question that's now completely decided by the court, the litigation's finished and everybody's carrying on with their lives, the Secretary of State can't then come back for a second bite of the cherry, of that same cherry, as it were, and say, I want to just ignore that judicial decision as if it hasn't happened and just remake the decision again. Because in those circumstances, there was no mechanism for remaking the decision because it was all finished. You know, that was a finished decision. We're in a completely different procedural circumstance here. So if we're relying on our procedural restrictions, it must be very important that we understand the procedural land that we're in here. And it's not an abuse for the Secretary of State to make a decision here, which is what we're, as I say, the other line of authorities are about. The question is, what do you do when you have a previous judicial decision? So are you disrespecting the previous judicial decision by making a new decision? No, you're not. That's not the territory we're in. But there is still this issue of how do we treat the previous decision? And as I say, it's not the case that in this jurisdiction it's completely ignored that there was a previous decision. That's where we get into Diva Sealand. And if we just looked at BK Afghanistan, which is tab 4 of the bundle, and you were shown earlier Lady Justice Rose's decision in that case. And if we could look at page 30, sorry, it's paragraph 39 on page 104. This is helpful in shedding light on how Diva Sealand fits in, because I think part of the issue here is that if you're not steeped in the whole immigration law and asylum litigation principles, it's quite hard sometimes to fit together. And you might have thought, without the guidance of Lady Justice Rose, that what's Diva Sealand about was this principle of res judicata, that what the concern of the court there was that there's some kind of principle of finality of litigation. But in fact, as you can see from paragraph 39, it's very clear that New Zealand's not at all about the problem, the mischief of a second decision being made. Because indeed it was actually concerned very much with a circumstance where everyone accepted there were going to be a second lot of decisions. I can actually remember those days. What happened was that all these asylum claims had been decided, and then the Human Rights Act came in, and there was now a right of appeal, just a general Section 65 right of appeal on any human rights kind of point. And so the courts were faced with a situation where all those asylum decisions were going to be relitigated on the basis of human rights, because it was, there was a right of appeal. And so the problem was then posed, well, what does one do? Because if one just ignores the asylum decisions on exactly the same grounds, there's a problem of inconsistency of judicial decision making, as well as, of course, the obvious situation where some people will relitigate, as it were, just hoping to roll the dice and get a different decision or to play things out. And so that's what Refusal is about. And Refusal is about what to do in the very situation we have here, where we have some judicial findings that were taken on the basis of the evidence at that time. So those findings are, in Refusal terms, linked to the state of the evidence at the time about what was there. They're not ignored, and they weren't ignored in this case. The second tribunal follows Refusal and says, I look at that, I don't rush in to reopen them without considering if there's new evidence. But new evidence means that you can and should look at the position in the light of all the up-to-date information. So here, there's no, and that's open to both sides. That's the interesting point here, is that it's a very even-handed principle, as it were. There's no abuse here. The Secretary of State is not, as I say, behaving in a way that the tribunal perceives as abusive or disrespectful to a final judicial decision. Because it's not that type of decision. As I say, in the other lines of authority, you'll see that, and my lord picked it up, that there was a finding, the basis of the decision that was recorded was in Willow, was that there had been an entitlement to indefinite leave to remain. Well, my learned friend nuanced that and said, well, of course, the court couldn't really have meant the person was entitled to indefinite leave to remain because there's always a discretion of the Secretary of State, etc., etc. But it's immaterial that, because that wasn't a case about discretion and the Secretary of State differing because of discretion. The point was there had been a decision on the whole question that was final. The person's immigration status, as it were. And that's not this situation at all. We have a remitted case. So the question has to be considered again. So it is the Refusal issue. We're in Refusal territory. What do you do with the previous judicial findings? You don't treat them as binding, because that's completely illogical as well. You consider them in their context, and then you say, if there's nothing more to do, which in some cases there isn't, as it were, if there isn't any new evidence, if there isn't any, yes, you've got to look at this again because the procedure is there to do it and there's a need to do it, but if there's nothing new, you don't just, as I say, ignore the previous judicial decision. Here, it's the Refusal situation where there is new evidence and there's no abuse. So why on earth would a procedural barrier be erected in this statute? So that's showing that the First Tier Tribunal didn't err in law in the way it treated it. And of course the submission must arise that none of this was put to the First Tier Tribunal judge. There's no appeal ground not in accordance with law, because in fact, truly, if one was taking this correctly, the applicant should have judicially reviewed the Secretary of State for making a decision on a matter that wasn't open to her. That actually is what the authorities say. It might be argued, well, she didn't need to, because she's under the old rules, and it has been held that they're not in accordance with the law ground of appeal, is effectively the same as judicial review and can look at that idea that the Secretary of State, shouldn't have been doing it this way. And so she had that alternative option, but she didn't take that option. She didn't make any of these arguments, and she went along with the approach that the Secretary of State was entitled to make the decision and argued out the appeal in front of Judge White. And he's very careful about that. He's very careful in saying, it wasn't put to me, I wasn't entitled to look at this. And before he goes on to look at all the evidence and to reach his judicial findings. So in my submission, there is a procedural bar on the, and indeed, something this court is pretty careful about, allowing new points to be litigated that weren't properly litigated below. Now, I accept, of course, that in front of the upper tribunal, there was this point taken, but by then in my submission, the upper tribunal was in the same position, that the upper tribunal shouldn't be overturning a first-tier tribunal decision on a ground of appeal that wasn't even raised as a ground of appeal before the first-tier tribunal decision. And so, in my submission, that's the other, not only is this a bad point, as it were, it isn't really a point properly open to my learned friend, unless the test that this court has raised is a Robinson test. On the statutory scheme, it's been looked at as well in GS India, and it said that it doesn't necessarily have to be Robinson, which is the point is obvious because it's all asylum law and one mustn't let it go. There is a sort of wider discretion, but the court's jurisprudence on it, quite understandably, is that a court would be very slow to start embarking on a point, and a questionable point is not good enough. A questionable point that's really talking about generalised principles. And in my submission, misapplying the jurisprudence, because if there had been a binding authority, my lords, then that's one thing. If a tribunal has missed a binding authority, then one can see it's almost like a per incuriam decision. Something that decided the outcome has been missed, and therefore it is something the court should look at. The appeal court or appeal tribunal should look at. But that's not this point. What's said here really is there are these quite flexible principles which are competing with each other in this case, because you've got it's said the finality of litigation, which in my submission I've already said this is not about finality of litigation at all. Competing with looking at all the relevant information and making a public law compliant decision. Because that's what the obligation on the Secretary of State is to do. And if one's going to cut across that, a statutory obligation, by legal principle, then there has to be a justification in law for doing that. Now, sometimes the justification is public law principles, and sometimes the justification might be abuse, and sometimes the justification might be respect for judicial decisions. But in my submission, none of those things apply here. There just is no foundation.
What was your third point, sir?
Respect for judicial decisions.
Thank you.
You said that there was a statutory obligation. Excuse my ignorance. Which statute? What section? What obligation?
Well, it would be the sections that have been referred to. The statutory obligation is just section 3, I think, of the Immigration Act of 1971, which is to adjudicate on applications believed to remain effectively. There's also in section 3 an obligation to take account of your immigration rules that the Secretary of State makes, and they're in the immigration rules as to how this statutory obligation to consider applications believed to remain is exercised. The immigration rules constrain the discretion effectively to say this is how we will do applications in this particular area. So it's a combination of statute and public law really, because the statutory section 3 is permissive. It says the Secretary of State can grant leave to remain. Public law says if someone applies to you leave to remain, then you must consider the application. So, under your scheme, if you've held yourself open to receiving applications, then you must consider it. So, principle of administrative law. I think Mandela is the best authority for this principle of administrative law. It's called the principle of good administration, which means that you effectively stick with your rules that you've published unless there's good reason to depart from them. So in this instance, as I say, there's none of the triggers for intervention for creating a procedure or a procedural bar or a principled different treatment for the Secretary of State's approach apply, because there's no abuse here. There's, as I say, there's no necessary conflict of judicial decisions. As I say, there's a perfectly good mechanism for reconciling a past judicial decision with the current one. And so there really is no material error of law, and without harking back on it, of course, the jurisdiction of this court is material error of law. So my learned friend doesn't point to anything the upper tribunal have done wrong, other than not intervening in the First Tier Tribunal's decision. And as I say, the basis that is said to justify intervention in the First Tier Tribunal decision is that he made an error of law, the First Tier Tribunal judge, by not applying the sort of ladder-marshal approach on the basis it was an abuse to make a decision at all. Because that's the only reason why it matters whether or not the Secretary of State, was it abusive for the Secretary of State not to appeal the First Tier Tribunal decision, but to consider all the evidence when considering the application? That must be the abuse, and in my submission there isn't abuse in there.
So the only course open to the Secretary of State, says Mr. Malik, is to have gone back to the first tribunal. We're calling them first and second. It would be revisiting the first tribunal and satisfying them under Ladden-Marshall that it should reconsider the matter.
I mean,
Ladden-Marshall is an appeal.
Is an
appeal authority, but it appears to be being used in this context as a reopening authority.
That's where I indicated my learned friend had got myself in a bit of a knot, with the greatest respect, because the you either say because it's a final judicial decision, you have to go back and reopen it, right? In order to be able to do what you want to do, you have to reopen that final judicial decision, and in that case, it is an appeal out of time, because there's something binding about the first decision. That means you can't embark on making.
Well, could you just educate me to these matters that what is what was, for our purposes, the extent of the reopening jurisdiction of a tribunal?
I was hoping that they were asking that, because I think the remittal might be the difficulty even for the Secretary of State, because normally you can only appeal if that is your only route, as it were. That if you can have probably, I have to look at the dates. The 2007 Act allows, and the procedural rules, allows the tribunal to, on an application for appeal, permission to appeal, to actually consider the decision and
yes, so that's typically used where there's been some error. Yes. So instead of going through the whole appeal process, the error is corrected, yes. and on you go. But I mean, there are various possibilities in the situation that has arisen. One is that Secretary of State, having been knocked back by the tribunal first time, could apply to the upper tribunal seeking to advance new evidence.
Yes, I think it would have to be...
And satisfy Ladden-Marshall in that way?
I think it would have to be an application for permission to appeal out of time. So I think the barrier is not in the sense of...
Why would it be out of time? Let's suppose the Secretary of State had nothing else yes. to think about, and gets the decision from Judge Randall, says, well, that's no good because I've got very grave doubts about this further material I've been provided with. So I'm going to immediately launch an appeal to the upper tribunal. Now, this is so unreal, is it not, when in fact the decision has been put back into the Secretary of State's hands. But following the logic of it, upper tribunal armed with Ladden-Marshall consider this appeal with the new evidence. Or go to the First Tier Tribunal again and knock on its door and say, think again with this new evidence, which may or may not have to satisfy Ladden-Marshall. But so far as Mr. Malik is concerned, the only thing that he, so far I've heard him to say, that the Secretary of State can't do is do what the tribunal has said she should do, which is to reconsider the matter, if he would say that involves looking again at the question of the genuineness of the bank documents.
Yes. I think it would have to be an appeal on an error of law, to be a material error of law, because
To go to the upper tribunal, that's it.
Because that's what the statute says. Quite what an error of law is, when errors of fact, error of law, I think you might be familiar with kind of E&R, and that's a slightly movable line.
Yes.
But I think something where there's fraud, I would imagine it might be said that if there are some errors of fact that are so stark that they are errors of law.
Yes.
That's E&R. E&R was where an adjudicator it was in one of those cases where it mattered what clan you were from, and I think it was Ethiopia, and I think that he just completely got all the relationships wrong, so couldn't have possibly understood the basis of the claim there, and he just completely misunderstood, and because it was such a complete misunderstanding, even though it was an error of fact, not an error of law, the jurisprudence was, well, that counts as an error of law.
There's plenty of authority that making a decision that no proper fact-finding tribunal could make on the evidence before it is a legal error.
Yes. And so I think it's in that territory anyway. So I'm not sure it would be a bar that it's a matter of fact rather than a matter of law as such. I think the appeal could be brought. I'm more worried actually about the fact that it's remitted to the Secretary of State for decision, because normally the appeal has to be final. The decision has to be final, and the only way of addressing it, and it certainly, it may not have been a bar to the Secretary of State, but I think it might be argued that, well, you don't need an appeal to remedy your situation here, because you've not got any. And that's why I was wondering if the tribunal, as you put to me, the first tribunal, had said you can't look at this, then I think the Secretary of State might not have been knocked back on the materiality, because the tribunal would have said, well, you've actually, the other tribunal, it's quite clear you can't go about your business.
All right.
Sorry,
Well,
I can't.
We'll adjourn at this stage. Can you give us some idea of how long you're likely to be this afternoon?
Well, my lord, I'd hope I wouldn't be more than half an hour, maybe less, depending on intervention.
Right. Very well. Well, 2 o'clock. Thank you.
All right.